Before starting our next topic, I would like to introduce our youngest director of any RVO, engineer Vaibhav Bansal ji. He is a qualified independent director and he has also have is a certified faculty for intellectual property rights, Nepal Ministry of Commerce and Industries. He is registered with the Independent Directors Data Bank IDDBF of Indian Institute of Corporate Affairs. He is BTech in Civil Engineering with this distinction from David Jalandhar. He has done before that he has done diploma in civil engineering with state board merit position and awarded appreciation from his Polytechnic M. Meherchand Polytechnic College Jalandhar. He has also done 6 months course in real estate valuation from Technological Development Center, PPDC, Ministry of MSME. He is certified gold appraiser from Technology Development Center, PPDC, Ministry of MSME. He is affiliate member of American Society of Civil Engineers. He is associated member of Institution of Engineers. He is also a chartered engineer. He has authored more than 6 books with ISBN registration, Department of Higher Education, Ministry of Education. And he is also a member of Punjab Press Club and sub-editor in CEV Techno News. At present, he is doing LLB and is a second year student of law. We will take his services for having certain knowledge about the Indian Succession Act, which you know is very important for a valuer to know about the basic details, which as an engineer or an architect, we cannot understand many things about this act. So especially for the Hindu Succession Act. So he will guide us certain basic things about this act. So after that, we will continue with our topic. So I request Engineer Vaibhav Bansal to give some details about this subject.
Thank you very much, sir. Thank you for my introduction. So friends, today we will discuss a very important terms of Hindu Succession Act 1956. So let me share my screen. Is my screen visible to all?
Yes, sir.
Yes, sir.
Yes, please.
Yes,
Is my screen visible to all? All of you?
Yes, sir.
Yes, sir.
Okay. So today we will discuss some salient features of Hindu Succession Act 1956. So first of all, we will discuss the applicability of this act. So the Hindu Succession Act 1956 came into force on June 17th, 1956. It was enacted by Parliament of India as Act 30 of 1956. The applicability, as per Section 2(1) of this act applies to any person who is a Hindu by religion. Next, to any person who is a Buddhist, Jain, or Sikh by religion. And the last, to any other person who is not a Muslim, Christian, Parsi, or Jews by religion. So this was the applicability, and now we will discuss the very important terms related to this section, which are generally asked in examination and also important for professional life as valuable. So first of all, we will understand the terms agnates, cognates, and collaterals. Under Hindu Succession Act 1956, the term agnate, cognate, and collaterals refer to different categories of relatives that are used to determine the order of inheritance. So agnates, these are the relatives connected solely through male lineage. Agnates have the highest priority of inheritance under the Hindu law. Example include a father, a grandfather, a grandson, and their descendants. As per section 18 in general terms, you can see that agnates are preferred over cognates and cognates are preferred over collaterals. Now cognates. Whenever in the relationship of a person with another, a female intervenes anywhere in the line, one is cognate to another. In agnates, there were wholly through males. But in cognates, anywhere in line, one cognate, one female intervenes there. So whenever a female intervenes anywhere in the line of succession, they are said to be cognate. They come after agnates in the order of succession. Examples include maternal relatives and siblings. The next term is collaterals. Relatives connected through common ancestor or ancestors, but not directly in the line of descent. That is, they are in parallel line. They have the lowest priority. Examples include siblings of the deceased and their descendants, means siblings of the deceased. Now, as per section 3A agnates, this section is in Hindu Succession Act 1956. In Hindu Succession Act 1956, section 3A agnate. One person is said to be an agnate of another if the two are related by blood or adoption wholly through males. By blood or by adoption wholly through males. As per section 3C cognate, one person is said to be a cognate of another if the two are related by blood or adoption, but not wholly through males.
Friend, this is very important concept, agnate and cognate. Many times a question is being asked on this topic. What is mean by agnate? What is mean by cognate? You must know what is mean by agnate and cognate. We will learn these things as mentioned in this table. It will be more clear if you read this table along with. Yes, Mr.
So here's a detailed comparison in tabular form. Agnates. Now the meaning of agnates. Agnates are relatives related through male lineage. In agnatic relations, the connection is through the male line only, In cognates, whenever in the relationship of a person with another, a female intervenes anywhere in the line, one is cognate to another. They include relatives on both father's and mother's side. In agnates, we are not concerned with mother's side relatives.
Can you please zoom in, please? Can you please zoom in a bit more?
Okay. Okay, sir. Now it is clear?
Yes, sir.
Yeah.
Thank you.
Yes, sir. Thank you.
Now in cognates, whenever in the relationship of a person with another, a female intervenes anywhere in the line, one is cognate to another. They include relatives on both father's and mother's sides. Now in collaterals, what is the meaning of collaterals? Collaterals are relatives related through a common ancestor, but not directly in the line of descent. That are siblings of the deceased, means brother, sister, etc. are the siblings of the deceased. They are called collaterals. They are in parallel lines. Now, preference in succession. This is very important.
Disease means about whose property we are discussing or whose property is to be distributed among the successors.
Yes, the deceased is also called propositus. We will discuss that term also in detail. Now, preference in succession. Agnates have precedence over cognates in order of succession, order of inheritance. Cognates are considered after agnates, but before collaterals. And collaterals are considered last in the order of succession. So collaterals are considered last in the succession, and agnates are considered have the precedence over cognates in order of inheritance. Now examples. Examples of agnates are full brothers and their descendants, like great-grandfather, paternal uncles, male descendants of these relatives. Cognates. The examples of cognates are maternal uncles and aunts. any other relative of the deceased, including maternal relatives. Now, collaterals. Examples of collaterals are siblings of the deceased, their descendants like nephews and nieces, cousins who are not direct descendants of the deceased parents. Now, legal status. Agnates have the highest priority in succession. Cognates have a secondary priority considered only after agnates. Collaterals have the lowest priority among these categories. Now we will discuss half-blood, full-blood, and uterine blood relation as per Hindu Succession Act 1956. As per Section 3E.
Friends, these relations are very important to be understood by every valuer. Anytime when you encountered a will during your visit and you have to value that property, and the person said that I have acquired this property as per will of my father, uncle, or any other relative, then you must know how to value this property and who is having the more right of ownership on that particular document. Yes.
Yes. So now we will understand various blood relations as per Hindu Succession Act 1956. As per Section 3E, full blood, half blood, and uterine blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife. And by half blood when they are descended from a common ancestor but by different wives. Two persons are said to be related to each other by uterine blood when they are descended from a common ancestress but by different husbands. So here fathers are different. Here in half blood, mothers are different. And in full blood, both are same. Mother and father both are same. So explanation, in this clause, ancestor includes father and ancestress include mother. Now, as per Section 18, full blood preferred to half blood. Heirs related to an intestate by full blood shall be preferred to heirs related by half blood if the nature of the relationship is the same in every other respect. So now let us discuss in detail in tabular form. Now, meaning of full blood. When the father and mother of two persons are the same, they are related to each other by full blood. In half blood, when two persons have the same father but different mothers, they are related to each other by half blood. And in uterine blood, when two persons have the same mother but different fathers, they are said to be related to each other by uterine blood.
So friends, is the three terms are clear in your mind? कोई doubt है तो पूछिए.
So if you have any doubt, you can ask between the lecture. Now, preference in succession. Full blood relatives have a higher priority in succession compared to half blood and uterine blood. In half blood relatives are considered after full blood relatives, but before uterine blood relatives. And uterine blood relatives are considered last in the line of succession among these categories. So now examples, full blood brothers and sisters, same mother and father, half brothers and half sisters, sharing the same father but different mothers, uterine brother and sisters, sharing the same mother but different fathers. Now, legal status, as per Section 18, as we have already discussed, full blood preferred to half blood. Heirs related to an intestate by full blood shall be preferred to heirs related by half blood if the nature of the relationship is the same in every other respect. Now, half blood relatives are recognized but are not given precedence over full blood relatives. As per the schedule of Hindu Succession Act 1956 explanation, this explanation is given in the schedule of the Hindu Succession Act 1956. In this schedule, references to a brother or sister do not include references to a brother or sister by uterine blood. So the references given in schedule of the Hindu Succession Act does not include uterine blood relation. Now, rights of child in womb. The child is in womb, not yet born. As per section 20, right of child in womb. A child who was in the womb at the time of the death of an intestate and who is subsequently born alive shall have the same right to
इंटरस्टेट में जिसने अपनी विल नहीं की है, यहाँ पर एक इंटरस्टेट एक वर्ड इस्तेमाल हुआ है। अगर कोई आदमी अपनी बिना विल किए उसकी डेथ हो जाती है तो उस केस में क्या क्या राइट्स होंगे आगे सक्सेशन के लिए? यस प्लीज।
A child who was in the womb at the time of the death of an intestate and who is subsequently born alive shall have the same right to inherit to the intestate as if he or she had been born before the death of the intestate, and the inheritance shall be deemed to vest in such as a case with effect from the date of the death of the intestate. So next, intestate succession. A person who dies without making a will is known as intestate. As per section 3, clause D, a person is deemed to die intestate in respect of property of which he or she has not made a testamentary disposition capable of taking effect. So where a person, जब कोई person ने will नहीं बनाई, अपनी वसीयत नहीं बनाई और उससे पहले उसकी डेथ हो जाती है, तो फिर जो प्रॉपर्टी होगी वो डीम टू डाई इंटरस्टेट उसको माना जाएगा और वो प्रॉपर्टी डिवॉल्व होगी अकॉर्डिंग टू दिस एक्ट, और इसके सेक्शन 8 उस पे अप्लाई हो जाएगा, सेक्शन 8 ऑफ हिंदू सक्सेशन एक्ट 1956. नाउ टेस्टिमेंटरी सक्सेशन. एज पर सेक्शन 30 टेस्टिमेंटरी सक्सेशन, any Hindu may dispose of by will or other testamentary disposition any property which is capable of being so disposed of by him or by her. The words disposed by him or by her was added by Hindu Succession Amendment Act 2005. In accordance with the provisions of the Indian Succession Act 1925 or any other law for the time being in force and applicable to Hindus. So testamentary succession होती है जब उसने will बनाई है, when there is a will. Now here's a person who is entitled to inherit property after the death of the intestate is known as heir. As per section 3 clause F, heir means any person, male or female, who is entitled to succeed to the property of intestate under the act. Now, descendants and ascendants. Sometimes this term might confuse you. Who are descendants and who are ascendants? Now, descendants. Descendants means the offspring of a person. Immediate descendants of a person are his sons and daughters. A person may have descendants through his sons or daughters up to any degree of descent. For example, son, grandson, daughter, granddaughter, etc. Now, ascendants. Ancestors of a person are known as ascendants. Immediate ascendants of a person are his father and mother. For example, father, grandfather, great-grandfather, mother, grandmother, etc. Now, the term proposita. The term proposita refers to the person whose property is being dealt with in a succession matter.
Sometimes when you read a will or a document, testamentary document, you may encounter this word proposita. What is meant by proposita? You must know.
It is essentially the individual who has passed away and whose estate is being inherited or disposed of under the laws of succession. Proposita refers to the deceased person who is the subject of the succession, and the law determines how their property will be distributed among the heirs. In simple terms, proposita means the deceased individual whose succession is being discussed or decided. Now, general rules of succession in the case of males. As per Section 8, general rules of succession in the case of males, the property of a male Hindu dying intestate shall devolve according to the provisions of this chapter. Firstly, upon the heirs being the relatives specified in Class 1 of the schedule. Secondly, if there is no heir of Class 1, then upon the heirs being the relatives specified in the Class 2 of the schedule. Thirdly, if there is no heir of any of the two classes, then upon the agnates of the deceased. And lastly, if there is no agnate, then upon the cognates of the deceased. So, as per the provisions of this act, if a Hindu male dies intestate, then the following persons can make a claim. First claim, first Class 1 legal heirs. They have equal rights to the assets. They are mother, spouse, children, etc. If any child has died, then their children and spouse have an equal share. Second claim, in the absence of Class 1 heirs, the Class 2 heirs can make a claim. They are father, sibling, living children, grandchildren, siblings, children, etc.
Here you must concentrate on the second claim. Father comes in second claim, not in first claim. Father is a second class higher, not a first class higher. You must know this.
So now third claim, in the absence of Class 1 and Class 2 heirs, the agnates can make a claim. Agnates can be defined as distant blood relatives of male lineage, father's side. And the fourth claim, in the absence of Class 1, Class 2 heirs, and agnates, the cognates can make a claim. Cognates can be defined as distant blood relatives of a female line. So firstly जो है वो Class 1 heirs को ही जो है प्रॉपर्टी उन्हीं को शेयर मिलेंगे. सेकंड क्लेम किनका होगा? इन द एब्सेंस ऑफ Class 1, मतलब Class 1 में जो 16 रिलेशंस मेंशन्ड हैं शेड्यूल में, अगर उनमें से कोई भी रिलेटिव जो है उसका अवेलेबल नहीं है, तो सेकंड क्लेम Class 2 हेयर्स को मिलेगा, जो कि उसमें एंट्री वाइज उसमें 9 एंट्रीज हैं शेड्यूल 2 में. तो उन 9 एंट्रीज में वो मेंशन्ड है. जो फर्स्ट एंट्री होगी वो सेकंड एंट्री और लास्ट एंट्रीज को एक्सक्लूड कर देगी, और जो सेकंड एंट्री होगी वो उसके नीचे वालों को एक्सक्लूड कर देगी. तो हायर द एंट्री द लोअर विल बी एक्सक्लूडेड. सो सेकंड क्लेम Class 2 हेयर्स को मिलेगा. और थर्ड क्लेम जो है, अगर Class 1 और Class 2 दोनों हायर्स नहीं है तो एग्नेट्स को मिलेगा. एग्नेट्स अभी हम डिस्कस कर चुके हैं कौन होता है. और फोर्थ और लास्ट क्लेम किनको मिल सकता है? कॉग्नेट्स. तो कॉग्नेट्स लास्टली प्रेफर करे जाएंगे. और अगर कॉग्नेट्स भी नहीं होते, एग्नेट्स भी नहीं होते, Class 1 Class 2 कोई हायर नहीं होता किसी का, तो फिर एस्टीट होती है. एस्टीट क्या होती है वो हम आगे डिस्कस करेंगे. नाउ these are the Class 1 heirs. These are 16 relations mentioned in schedule of the Hindu Succession Act 1956. You can see here some important, very important relations are mentioned here, like son, daughter, widow, mother, son of predeceased. Predeceased का मतलब है जो सक्सेशन ओपन होने से पहले ही उसकी डेथ हो चुकी थी, मतलब प्रोपोसिटस से पहले उसकी डेथ हो चुकी. He died before the propositus. Now second आता है daughter of predeceased son, son of a predeceased daughter, daughter of predeceased daughter, widow of predeceased son, son of a predeceased son of a predeceased son, daughter of predeceased son of a predeceased son, widow of a predeceased son of a predeceased son. Now, these within the bracket are added after the amendment of 2005. ये जो सारे रिलेशन आप ब्रैकेट में देख रहे हो जिनके आगे 1 लिखा है, ये सारे जो ऐड किए गए थे वो 2005 की अमेंडमेंट में किए गए थे. तो कि यहाँ पर कुछ ऐसे कोग्नेटिक रिलेशंस थे जो नहीं थे Class 1 हायर्स में, ये Class 2 में थे ऑलरेडी, लेकिन इनको अमेंडमेंट के बाद Class 1 में ऐड कर दिया गया ताकि इनके साथ भी इक्वल जस्टिस हो सके. नाउ Class 2 हेयर्स. Class 2 हेयर्स में ये जो 1, 2, 3 रोमन न्यूमेरिकल्स में लिखा है, ये सब एंट्रीज है. जो भी फर्स्ट एंट्री में होगा वो बाकी सबको एक्सक्लूड कर देगा. जैसे फादर, सो फादर फर्स्ट एंट्री में है, तो ये लास्ट के सारे जो है इनको कुछ भी नहीं मिलेगा अगर फादर इस वक्त जो है वो मतलब जिंदा है, मतलब वो अभी लिविंग पर्सन है, तो फिर इनको कुछ भी नहीं मिलेगा. अगर फादर नहीं है तो ये सेकंड एंट्री में सन्स डॉटर सन, सन्स डॉटर्स डॉटर, ब्रदर सिस्टर, इनको फिर शेयर मिलेगा और बाकी सबको नहीं मिलेगा. ऐसे ये एंट्रीज 1 2 3 4 से लेके 9 तक है। और इसमें लास्ट रिलेशन है मदर्स ब्रदर एंड मदर्स सिस्टर, मतलब मामा और मासी, ये लास्ट में। नाउ की टेक अवेज फ्रॉम क्लास 2 हेयर्स। Father is the only nearest heir who has not found a place in class 1 heirs. As per the Mitakshara notion of propinquity.
Friends,
अब ये
it is very important concept. It is very important concept to be understood by everyone. Father is the only nearest heir who has not found a place in class 1 heir. Very important. हालांकि हम जब भी बोलते हैं लेट इट बी, किसी का नाम बोलते हैं उसके साथ सन ऑफ उसके फादर का नाम जरूर लगाते हैं, लेकिन लीगली father is the only nearest heir who is not found a place in class 1 heir. It is very important concept to be learned by every valuer. कभी कभी अभी एक कोर्ट का केस हुआ है, उसमें ये हेल्ड किया गया है कि ऐसा, ये अगर आप इग्नोर करते हैं, मैं ज्यादा डिस्कस नहीं करूंगा, अगर आप इग्नोर करते हैं तो यू कैन बी इन ट्रबल while valuing a property. Yes, please continue.
Yes sir, thank you. So as per Mitakshara notion of propinquity, अब ये मिताक्षरा क्या है? There are two schools in Hindu law, two major schools. One is Mitakshara and other is दयाभाग. मिताक्षरा जो है वो नॉर्थ इंडिया और सारे इंडिया में एप्लीकेबल होता है, लेकिन दयाभाग सिर्फ और सिर्फ जो है वो बंगाल साइड में ही एप्लीकेबल होता है और ईस्टर्न स्टेट्स में एप्लीकेबल होता है। सो मिताक्षरा को ही इसमें कंसिडर किया गया है। और एज पर मिताक्षरा नोशन ऑफ प्रोपिंक्विटी, अब प्रोपिंक्विटी का मतलब होता है नियरनेस ऑफ रिलेशन, दैट अंडर द मिताक्षरा लॉ मदर वॉज कंसिडर्ड टू हैव ग्रेटर प्रोपिंक्विटी देन फादर। सो मदर को जो है वो ज्यादा नियर माना जाता है फादर के। और इवन इन द केस ऑफ लिजिटिमेट एंड इलिजिटिमेट सन, जो मदर है उसका राइट जो होता है प्रॉपर्टी पे होता है, और जो इलिजिटिमेट सन होता है उसका प्यूनेटिव फादर की प्रॉपर्टी पे राइट नहीं होता, लेकिन अपनी मदर की प्रॉपर्टी पे राइट होता है। सो इसीलिए मदर को ग्रेटर प्रोपिक्विटी कहा जाता है। नाउ फादर इज द सोल हेयर इन कैटेगरी 1 एंड इन द एब्सेंस ऑफ क्लास 1 हेयर्स ही टेक्स द एंटायर प्रॉपर्टी। सो अगर क्लास 1 में कोई भी नहीं है तो फादर अगर उस वक्त लिविंग पर्सन है तो फादर को एंटायर प्रॉपर्टी मिल जाएगी और बाकी सबको वो एक्सक्लूड कर दे, पर क्लास 1 के ना होने पे। नाउ ब्रदर्स एंड सिस्टर ऑफ इक्वल रैंक इनहेरिट इक्वली। व्हेन देयर इज ब्रदर और सिस्टर बाय फुल ब्लड, ब्रदर और सिस्टर ऑफ हाफ ब्लड इज एक्सक्लूडेड। सो फुल ब्लड जो है वो हाफ ब्लड को एक्सक्लूड करते हैं, जैसा हमने पहले पढ़ा। The brother and sister by uterine blood are excluded. ब्रदर और सिस्टर ऑफ यूट्राइन ब्लड जो है वो कभी भी पिक्चर में नहीं आते जब तक कि हाफ ब्लड और फुल ब्लड है, और अगर हाफ ब्लड और फुल ब्लड नहीं है तो वो आ सकते हैं। लेकिन शेड्यूल में जो लास्ट में जो एक्सप्लेनेशन है उसमें ये लिखा हुआ है द ब्रदर एंड सिस्टर बाय यूट्राइन ब्लड आर एक्सक्लूडेड। नाउ ऑल हेयर्स इन क्लास 2 इनहेरिट पर कैपिटा। पर कैपिटा मींस पर हेड। Now, this is very important term is cheat. As per section 29, failure of heirs. If an intestate has left no heir qualified to succeed to his or her property in accordance with the provisions of this act, such property shall devolve on the government. So, अगर क्लास 1, क्लास 2, एग्नेट, कॉग्नेट कोई भी रिलेटिव नहीं है तो वो प्रॉपर्टी जो है वो गवर्नमेंट को चली जाएगी। इसी को चीट कहते हैं। एंड द गवर्नमेंट शैल टेक द प्रॉपर्टी सब्जेक्ट टू ऑल द ऑब्लिगेशंस एंड लायबिलिटीज टू विच एन हायर वुड हैव बीन ए सब्जेक्ट। नाउ वी विल डिस्कस a very important topic, disqualification of an heir under the Hindu Succession Act. Who can be disqualified from succession? As per section 25, murderer disqualified. A person who commits murder or abets the commission of murder shall be disqualified from inheriting the property of a person murdered or any other property in furtherance of the succession to which he or she committed or abetted the commission of the murder. So अगर कोई
yes please continue.
अगर कोई मर्डर करता है या उसकी कमीशन में असिस्ट करता है यानी अबेट करता है तो फिर उसको डिस्क्वालीफाई कर सकते हैं। फॉर एग्जांपल, अगर कोई सन इन अपनी प्रॉपर्टी लेने के लिए फादर का मर्डर कर देता है तो ऐसे में उसको वो प्रॉपर्टी नहीं मिलेगी, क्योंकि उसने सक्सेशन के लिए फादर का मर्डर कर दिया, तो कि वो सक्सेशन वो प्रॉपर्टी लेना चाहता था, तो उसने उसी इंटेंशन से उसका जो वो था, मतलब एनिमस था, वो यही था कि वो प्रॉपर्टी ले, सक्सेशन करे, तो ऐसे में उसको प्रॉपर्टी नहीं मिलेगी। नाउ एज पर सेक्शन 26 कन्वर्ट्स descendants disqualified, where before or after the commencement of this act, a Hindu has ceased or ceases to be a Hindu by conversion to another religion, children born to him or her after the conversion and their descendants shall be disqualified from inheriting the property of any of their Hindu relatives unless such children or descendants are Hindus at the time when the succession opens. अब यहाँ पर एक चीज इंपॉर्टेंट है कि यहाँ पर जो कन्वर्ट हुआ वो डिस्क्वालीफाई नहीं हुआ, क्योंकि कास्ट रिमूवल एक्ट 1850 के अकॉर्डिंगली क्या है कि जो व्यक्ति कन्वर्ट होता है वो प्रॉपर्टी में अपना हक ले सकता, उसकी सक्सेशन नहीं हटाई जा सकती, लेकिन जो उसके चाइल्ड बॉर्न हुए वो उसी रिलीजन के होंगे जिसमें वो कन्वर्ट हुआ, तो वो चाइल्ड जो है वो एक्सक्लूड कर दिए जाएंगे, उनको कुछ नहीं मिलेगा। यहाँ क्लियरली लिखा है कन्वर्ट्स डिसेंडेंट्स डिस्क्वालीफाइड, नॉट कन्वर्ट डिस्क्वालीफाइड। सो कन्वर्ट के जो डिसेंडेंट्स होंगे, जो उसके चिल्ड्रन होंगे, हमने भी डिसेंडेंट्स भी पढ़ा है कि जो उसके चिल्ड्रन होते हैं, तो वो सारे के सारे जो है वो डिस्क्वालीफाइड हो जाएंगे, क्योंकि वो कन्वर्ट के चिल्ड्रन है और उनका रिलीजन वही है, वो पहले कभी भी हिंदू नहीं थे, इसीलिए वो डिस्क्वालीफाई हो गए। नाउ एज पर सेक्शन 27 सक्सेशन व्हेन heirs disqualified, if any person is disqualified from inheriting any property under this act, it shall devolve if as such person had died before the intestate. So यहाँ बेसिकली ये माना जाएगा कि वो पर्सन एग्जिस्ट ही नहीं करता, जो डिस्क्वालीफाई हो गया है वो ये माना जाएगा कि वो एग्जिस्ट ही नहीं करता, तो वो कम इनटू पिक्चर आएगा ही। नाउ द लास्ट, एज पर सेक्शन 28, डिजीज, डिफेक्ट एक्सेट्रा नॉट टू डिस्क्वालीफाई, no person shall be disqualified from succeeding to any property on the ground of any disease, defect or deformity, or save as provided in this act on any other ground whatsoever. So disease, defect, deformity जो है अब डिस्क्वालीफाई उसके बेस पे कोई नहीं होगा। हिंदू सक्सेशन है 1956 आने के बाद डिजीज और डिफेक्ट को अब डिस्क्वालीफाई नहीं माना जाता। So thank you very much for listening me. If you have any doubt, you can ask.
So friends, if you are having any doubt related to this topic, you may unmute yourself and ask the question, or you may raise your hand.
बांसु जी।
Yes sir, yes sir.
बांसु जी, बांसु जी,
Yes sir.
बहुत बहुत मुबारक, नाइस रिप्रेजेंटेशन बाय वैभव।
Thank you, sir.
Okay. We met on January 20 when you are doing degree at second year, if you remember.
Yes sir, yes sir. I think it was gold valuation
Yes,
course.
gold appraisal course.
Gold
No, when we have delivered COP.
Okay.
Yes, sir. In COP also.
2020 before COVID.
Yes, 29th of
होटल
September.
था कौन सा? हाँ, ये के
29th of September.
Very nice, very nice.
Thank you, sir.
Thank you, Mr. Vaibhav Bansal ji.
Thank you, sir.
And I have a small doubt.
Yes, sir.
As we are taking course under the Companies Act, can we, after obtaining the being certified by as a valuer, can we go for the valuation of a family?
Sir, I am unable to hear you. There is a noise in background.
Sorry, sir. After the session, okay, I'll try to chat it.
Yes, sir.
Yes.
Okay, thank
Sir, I have a question.
Yes, sir.
See, if a person is convicted, as you said, if a person in a succession is making a murder, he is
Yes,
not
sir.
eligible for the rights of a property. In the same way, if a person is murdered in some other activity, let's say he did some murder activity outside, so do he has a right for the property?
Sir, if he has murdered the propositus, then only he is disqualified. If he is a murderer in any अगर उसने किसी और का मर्डर कर दिया तो वो कम इनटू पिक्चर नहीं आएगा। ओनली जब उसने प्रोपोसिटस का मर्डर किया तभी, फॉर सक्सेशन पर्पस ओनली। हियर फैक्टम एंड एनिमस इज दैट कि उसने अपने प्रोपोसिटस का मर्डर किया है, जिसके उसने सिर्फ और सिर्फ सक्सेशन के लिए मर्डर किया।
क्लियर। मेरा फाइनल डाउट है,
Yes,
देर आर टू सिबलिंग्स, वन इज सिस्टर, वन इज ब्रदर.
yes,
So there is interstate condition. The brother has been converted into Christian religion. Okay.
yes, sir.
So now the property has to be distributed. So
Yes, sir.
how these two will be liable for the property, or only the sister can take the property?
Sir, both will take property equally, half half. As मैंने पहले भी यहाँ पर डिस्कस किया था, convert descendants are disqualified, not the convert disqualified. If he is predeceased, then he will take nothing. But if he is living person, he will take his share.
Okay, thanks.
मीन्स
Sir,
सर
but
वो पर्सन एलिजिबल होगा सक्सेशन लेने के लिए, लेकिन उसके जो आगे सक्सेसर्स आएंगे वो नहीं होंगे, क्योंकि वो पहले हिंदू था, हिंदू के बाद कन्वर्ट होके क्रिश्चियन या व्हाट एवर इट इज किसी भी रिलीजन में चले गया, तो उसमें वो तो खुद पहले हिंदू रहा है, लेकिन उसके जो आगे सक्सेसर्स होंगे वो हिंदू नहीं कहलाएंगे, तो इसलिए हिंदू सक्सेशन एक्ट में उनको सक्सेशन नहीं मिलेगा। लेकिन अगर वो कन्वर्ट हुआ है, इमीडिएट कन्वर्ट वाले को उसको मिलेगा, उसके ब्रदर को मिलेगा, ब्रदर के बच्चों को नहीं मिलेगा।
सर, इसके ऊपर एक लेजिस्लेशन है, कास्ट डिसेबिलिटी रिमूवल एक्ट 1850, वो उस पर एप्लीकेबल हो जाता है, तो हम उसको एक्सक्लूड नहीं कर सकते, क्योंकि उसका राइट है अपने फादर और मदर की प्रॉपर्टी पे। लेकिन उसके जो चिल्ड्रन हैं, जो उसके डिसेंडेंट्स हैं, उनको हम कंप्लीटली एक्सक्लूड कर सकते हैं, अगर वो उसकी डेथ हो चुकी है तभी, अदरवाइज नहीं।
sir, in class 1, the predeceased wife was included, no, sir?
1 minute.
Yeah.
In class 1, what?
One. In class 1, there was a point where the widow of the predeceased is included.
The widow of
क्लास
the
1 है,
predeceased.
क्लास 1 है।
Yes, widow is included. In class 1,
But you
widow
said-
is included.
Okay. But
And
but
widow
in the
will
last
take
point,
equal share. And widow will take equal share as mother and son.
but in that last slide, the predeceased son is not included, no?
Where?
Last slide, sir. Last
Disqualification.
slide. Yeah. Disqualification. Yeah.
Where it is mentioned?
Sir, third point, section 27. If the person,
If any person is disqualified from inheriting any property under this act, it shall devolve as if such person had died before the intestate. Here it means कि वो पर्सन डिस्क्वालीफाई हो, जो पर्सन जो मर्डरर है या कन्वर्ट के डिसेंडेंट्स हैं, उनकी प्रॉपर्टी जो है वो जो है ऐसे मानी जाएगी जैसे वो एग्जिस्ट ही नहीं करते। इसमें कहीं विडो का कॉन्सेप्ट नहीं है।
So friends, this is all for this session. If you are having any question, you may send in WhatsApp to me or to Vaibhav. His number is available on the website, also in director section. And one detailed presentation on Hindu Succession Act is available on our YouTube channel, and that is available free of cost to everyone. If you go through it, you will also learn many things in addition to this syllabus. It is very important slide and a very important presentation, and everyone need to understand the Succession Act as applicable in India. So Vaibhav, Mr. Vaibhav, thank you very much for sparing your valuable time during your examination period also. Highly grateful to you. Goodbye. Good luck.
Thank you, sir.
Thank you, Mr. Vaibhav.
Thank you. Thank you.
Thank you, sir.
So friends,
Thank you, sir.
Thank you, Engineer Vaibhav Pansalji. So we will continue with our topic which we were discussing before the break. So next topic, as far as syllabus is concerned, is Transfer of Property Act 1882. So this act basically governs the